DataAgenda Datenschutz Podcast, der Expertentalk mit Professor Dr. Rolf Schwartmann.
The world's first AI law. This is Rolf Schwartmann talking to Zenner in DataAgenda Datenschutz Podcast. Today is December the 12th, 2033, and after marathon negotiations from December 6 to 9, 2023, the future of AI regulation seems secure. In the DataAgenda podcast, Zenner, head of office and political advisor to a member of parliament of the European Parliament, Axel Voss, reports on what the representative of the Council, Commission and European Parliament have agreed on and how things are progressing and whether there was any gambling during the negotiations. Zenner, was there any gambling?
Well, a little bit. Let's say I think there was a gambling to really close this file as soon as possible, and many people didn't check the text in that level of details that they maybe should have. So it was really speech was trumping a little bit the quality. But yeah, I think it's normal in politics, and especially with the AI Act, there was huge time pressure to close the file as soon as possible in order to make it happening before the European election next year. And yeah, I think this needs to be taken into account when we are trying to assess what happened last week.
Okay, so the normal gambling in politics. But how is the mood after the agreement a week after? Did everyone get along again, or are there still disagreements?
Yeah, so I think first of all, everyone is extremely relieved that there seems to be a political agreement and that it's now almost over. Because if you are thinking a little bit, especially when the parliament started to work on AI, this was 6 years ago. And for offices like the one from my boss, Axel Voss, and myself, we are now really for 6 years working on artificial intelligence, and especially the last 3 years on the AI Act have been really a rough and very hectic period that demanded a lot from both of us. On the other hand, especially Axel and myself, we are not super happy with the result. There are certain things that we really do not like within the European AI Act. On others, we are kind of happy with the end result. So personally, for us, it still remains a little bit unclear what our general assessment is. I think the same applies also to many other actors, but for those actors, I think it's more important now that we made a huge step forward, that the AI negotiations seem to be almost over, and therefore I do also not expect now some big problems on the road ahead because of this strong will of most involved actors to close everything. But nevertheless, we will still have a lot of technical meetings in the next weeks, especially until the first week of February. And in those technical meetings, we will still need to review large parts of the text. We will need to adjust certain articles to this political agreement that was being reached last week, and also continue to work on recitals and so on and so on. So it was a step forward. Again, for Axel and me, not 100% clear how positive it was. And second point, there is still a lot to do, especially on technical level, when it comes to technical adjustments and so on and so on.
Okay, but let's come to the achievements. From your point of view, what are the main results we have now?
Yeah, so let's say the main results or the agenda of the political trialogue, maybe I start there, was covering 21 items from real-world testing, fundamental right impact assessment, foundation models, governance, prohibitions, and so on and so on. Now all items are closed, are considered to be closed, and therefore the whole AI Act kind of stands, at least from, let's say, from the larger items, and therefore we would assess, Axel Voss and myself, at the moment that yes, it's a huge legislative piece that indeed tries to cover all AI systems in every sector, in every use case, and tries to do it with flexibility, but, and this we are criticizing from the beginning, we think on a conceptual level, the AI Act will never be able to do it in a correct way, because even though we improved large parts of the text, there will be still a lot of situations where we are asking a high-risk AI system to perform the operation in a certain way that is maybe not possible for an AI system in this sector, while it's even maybe necessary for a high-risk AI system in another sector. A second problem that Axel and I see in the AI Act is that due to his horizontal nature, let's say the risk categories and also the prohibitions in Article 5 are very, very broad, and therefore they are often covering rather useful deployment cases of AI technologies. And it's often not 100% clear if, for example, an anti-fraud mechanism that is being used by a bank or an insurance in order to prevent fraud could not maybe certainly be prohibited, banned, or maybe classified as high risk, which could have crazy situation, or could lead to a crazy situation that this bank would need to be transparent about their anti-fraud mechanism, leading to a situation where the criminal would learn from the bank how the bank is trying to prevent him to commit a crime. So those conceptual problems are now still in the Act because it was just impossible to completely solve them. This may be as two negative points that Axel and I would see in the AI Act as it is now. On the other hand, on a more positive note, we as European Parliament, and especially we as EPP, achieved a lot of improvements when it coming to regulatory sandboxes, real-world testing, to other, let's say, more pro-innovation parts, so that it should really be much more easier for especially smaller companies to take a risk, to learn together in strong cooperation with public authorities how they can develop an AI system in order to be compliant with the AI Act. We also added a lot of new provisions when it's coming to the AI value chain in order to accelerate information sharing from top to down, which should help again, especially European SMEs and startups, and helps them again in order to become compliant. And maybe as a last point, we also fixed a lot of overlaps with other digital legislation, also contradictions when it comes to enforcement bodies from a sectorial law and now the AI law, and so on and so on. But at the moment, again, as I said at the beginning, Axel and I are still not really sure how our overall assessment will be, if despite those positive changes and the positive outcome, maybe the conceptual problems that I was also talking about are so severe that in the end, the AI Act will not really bring Europe forward when it comes to artificial intelligence. So there, I cannot really give our final assessment. It's still in the making.
Okay, but let us have a closer look at the foundation models or GPAI models, former known as foundation models. As I learned, it said there are specific obligations for manufacturers of such GPAI. This was a key point for the European Parliament. How is it concrete? And the background of the question is, where does the user's responsibility begin? Let's say users must be aware that they're interacting with a machine. What does that mean? How can they check the AI's advice if they lack the specific background knowledge that they obtain from the AI? And who is to blame if language models hallucinate or discrimination occurs from the database? Is the manufacturer or the user responsible? Well, these are questions that courts already have to answer today, regardless of any specific AI liability.
Yeah, good question. So as you underlined, indeed, it's not calling foundation models anymore, but general purpose AI models. In the end, the European Union opted for this two-tier approach that I also suggested in my OECD article from July this year, which means that similar to the Digital Services Act, DSA with its flops and very large search engines, also in the European Union, there will be two categories of GPAI models. The lower category means that those models, like, for example, from the German company Aleph Alpha, would need to fulfill in the future certain technical documentation obligations. Nothing more. So it's rather low regulatory burden, I would say. Then there's a second tier for systemic foundation models. Systemic means that, there is a systemic risk, but also that those models are rather powerful, that maybe humankind is still not 100% sure how those are functioning. So there is a little bit of a unpredictability element connected to those models, and so on and so on. Here, in the future, similar to the DSA, the Commission and there the AI office, which is integrated in the Commission, will need to make a kind of call if such a model really classifies as systemic. One of the criteria is the flop number, floating operation points per second, which was being set at 1025, which is the number that OpenAI's GPT-4 needed in the development. But there are also some other criteria that the Commission needs to take into account. After the designation of such a model, this model, or in this case OpenAI, would need to fulfill certain obligations. For example, model evaluation with red teaming, adversarial testing. So in order to make sure that the model fulfills certain, let's call it, safety criteria or minimum criteria. Then cybersecurity measures need to be taken. There need to be OpenAI would need to establish an incident notification mechanism, meaning that if there is an accident or something else goes wrong, they would need to notify the Commission about it. And there are also other smaller things like data governance and so on and so on. But I would say the points that I mentioned before are the most important ones. Then to your question, what about the users? What about downstream providers and so on? Well, this is all being solved in Article 28 and in the rest of the AI Act. If I would stick to my example of OpenAI, if now a company like SAP in Germany is taking ChatGPT and is building something on top, like, for example, a high-risk AI system in the area of employment, then SAP would need to fulfill completely normal the high-risk obligations of the AI Act. And then if the city of Heidelberg or Hamburg is using the high-risk AI system from SAP, then also the city would need to fulfill certain obligations that are listed in Article 29 of the AI Act. So it really depends a little bit where the defect or where the mistake happened. If it happened in the foundation model or general purpose AI model, if it happened in my example at SAP, or if it happened at the city of Heidelberg, for example. And on top of that, there can, of course, also be complementary liability rules. Very likely the European Parliament and the Council will in the next term work on the AI liability directive, which will then also talk about joint liability mechanisms. In my example, between the City Hall, between SAP and between OpenAI. So if then the City Hall would, for example, need to pay a fine, would need to be liable against a citizen from Hamburg, then maybe the City Hall could try to get itself redress from, for example, OpenAI or from SAP. So this is really a little bit a missing element, this liability question that will not be solved in the AI Act, but very likely then in this additional AI EU law that is currently already presented.
Okay, but I think you agree it sounds complicated.
Yes.
What you explained in the last minutes. And just to mention, we got two kinds of flops in future. One with F and one with V, very large online platforms of the DSA, and the, what is it, floating operating points of
per second. Yeah.
Per second. Okay. So let's hope that we all get along with this kind of terms. But another question, the last question I have is, I'm interested in the AI office and the AI board. Two new institutions we see in future. How do they relate to the market surveillance authorities, especially the data protection authorities in the member states? What is the relationship among them?
Yeah. It's a really interesting question because, again, a lot has happened in those political negotiations over the last week. And there were also some changes when it comes to the board and the office. So the final deal that is now on the table is the following. The AI office will be responsible for foundation models, or like they are called now, general purpose AI models. And both categories, so the normal ones and also the systemic ones. So it will be the office, which is integrated in the European Commission, probably in DG Connect, so in this department for digital matters. And this AI office in the future then needs, for example, to designate systemic models. They will need to as I already mentioned, check if there was an incident notification. They need to engage with foundation model providers when it's about this code of practice. They need to provide guidelines and so on and so on. So this is a kind of EU actor that is rather powerful and has a lot of possibilities to coordinate, to streamline enforcement and so on. On the member state level, there will be still some enforcement bodies that are also active when it comes to GPI models. But let's say the music plays really in Brussels, in the AI office, in the Commission. But again, this is only for this new chapter on general purpose AI models. The AI board is basically what the European Commission proposed in 2021 in their original proposal, which is a kind of body that is not as powerful as the EDPB from the GDPR. So it cannot make some binding decisions, for example, but the AI board is more a coordination mechanism. So it should coordinate all those different national competent authorities that are enforcing the rest of the AI Act. So prohibitions, high-risk AI systems, Article 52, the disclosure when it comes to deepfakes, and so on and so on. They are also trying to support the European Commission when it's coming to the drafting of guidelines, the sharing of best practices, and so on. But in all those areas, again, the member states remain the main actors, and this AI board cannot tell, I don't know, the Romanian government, for example, or the Romanian National Competent Authority that certain things are not in order and then overrule what this Romanian National Competent Authority wants to do. So it's really a different level of European enforcement within the AI Act. And then maybe a last point, in the next months, it will be also rather interesting for us to monitor what will happen on national level, because some member states will maybe opt for assigning their data protection authority as also the national competent authority for the AI Act, meaning that, for example, in Germany, our 17 data protection authorities would be the authorities for the AI Act, so 16 state authorities and our federal authority. But it could also happen that the cybersecurity agency in Germany, in Bonn, becomes the national competent authority, or someone else. But it has a huge impact, because let's say if the data protection authorities are the lead authorities, they will understand the AI mainly from their privacy perspective. Cybersecurity has a different perspective. Market authority or surveillance authority, a completely different again. What will happen is that France, Germany, Italy, Poland, Estonia, and so on will have different decisions, and therefore we will have, unfortunately, an extremely fragmented internal market, which futures very different enforcement mechanisms when it comes to different member states. And this is also one of the reasons why Axel and I have currently a rather mixed assessment when it comes to the AI Act, because we predict that this different enforcement mechanism will lead to a lot of problems when it comes to the application of the AI Act.
Well, I fully agree, and I can imagine that it's very complicated, and to find a fair balance of power is a very, very big deal, I think.
Yeah.
And it's more complicated than it was before in data protection terms, I think. Well, last question, Kai. Did we talk about the timetable? When will the regulation be published in the official journal of the EU?
Yeah. So if I'm right and those technical meetings are then successful, as I predict at the moment, then at latest, as I said, we would close the technical negotiations in the first week of February. And after the 9th of February, there's actually, it's not allowed to continue. So on this day, it's really make it or break it. Again, my prediction would be we make it. And after the 9th of February, then there will be first a vote in the committee, in the working group and co-repair of the council. Then there will be a vote in the plenary in the parliament and among the ministers in the council. And then in parallel, lawyer linguists, legal service will update the text, will improve the law, and there will be also, of course, the translations in, I think, 24 different languages. And if all of that is done, we still need to wait often a few weeks until the AI Act is published in the EU official journal. My prediction, if we are managing to have this deal on technical level until the beginning of February, probably publishing will happen in May or June, so really around the European election time. And what is important for everyone who is listening to our podcast is that then different transition periods are kicking in. There's one transition period of 6 months when it comes to the prohibitions in Article 5, meaning that if I'm right, and for example, the AI Act becomes a law in June, already in December or January, Article 5 is fully applicable. Then, when it comes to foundation models, there will be a transition period of 12 months. So there, especially the enforcement body, so the AI office, and other things that need to be prepared. Also, it's not a lot of time, but at least people would have 12 months. Then there is a third layer, which gives the sectors that are listed in Annex 2. So Annex 2 is, for example, machinery regulation, radio device regulation, RED, and others. Those would have 3 years to prepare for the AI Act, because in those areas there are already a lot of enforcement mechanism, technical standards, and so on. So here it's really about adjusting an already running system, and this probably will take more time. And all the rest of the AI Act will become applicable after 2 years. So there's a transition period of 2 years. Those 4 different transition periods have been chosen because of different time demands, as I just underlined when it comes to sectorial legislation listed in Annex 2. And I personally think that this was a rather smart move, because if everything would be applicable after 2 years, I think it would have been a complete chaos. I think this approach is a little bit better.
Okay, smart move. 6 months, 12 months, 24 months, 36 months.
Indeed.
4 layers, smart move. Okay, let's hope that we can deal with it. Yes, but thank you for this last advice for our listeners. Thanks a lot, Kai, for participating in this podcast, the world's first AI law. Today is December the 12th, and Kai Zenner is starting to get into his next technical meeting. Thank you that you took the time to be here, and good luck for the further negotiations, and goodbye to all listeners of the DataAgenda Datenschutz Podcast, and see you again, hear you again. Goodbye.
Thank you.
Das war der DataAgenda Datenschutz Podcast, der Expertentalk mit Professor Dr. Rolf Schwartmann.